Well, there's talk about reforming the Supreme Court. And to be honest, there's been talk about reforming the Supreme Court probably as long as I've been alive and probably before that as well. And typically it occurs when one side believes that they are being put upon unfairly, so then the reform demands seem to occur. I'm going to be looking at two different plans from the left and the right. We have the Biden plan and the Levine plan. Uh, Mark Levin. It's actually Levin. I'm going to keep saying Levine. It's not to be disrespectful. It's just I read it before I heard it, so it stuck in my head. So I'll give you a quick overview of what Biden and Levin have in mind for their Supreme Court reforms. Give a little bit of historical background, and then give you my opinions on what might come of it. So Levin wants 12-year term limits on the Supreme Court. Biden wants 18-year term limits. Biden wants to impose a binding code of conduct via the Congress. Levin wants to allow Congress or the states to overturn Supreme Court decisions with a three-fifths vote of either Congress or the legislatures of the United States within 24 months of a decision. So basically, there'd be a time clock on any decision running for two years. After that, it would be precedent. During that time, it would be up for a potential contest. And Biden wants to increase the Supreme Court to 13 members from its current 9. So understand a little bit about what the Constitution says about the Supreme Court. The Supreme Court is probably interesting in that it has very little definition, and most of its definition, specifically via the Constitution, says Congress basically shapes it. If we are to believe Hamilton, he said that he saw the Supreme Court or the justice system in a whole being the weaker of the three branches of the government, whereas Congress would be the most powerful. The president or the executive branch would be very close to power of the Congress, and the Justice Department would be much weaker. The Constitution does demand that there must be a Supreme Court, and it gives the power to Congress to create any inferior courts. The general powers that the Supreme Court has comes from the Constitution. However, the implementation of those powers come from Congress. The Constitution gave the Supreme Court original jurisdiction over certain items. Original jurisdiction means the Supreme Court tries the case directly as like a regular court, but these are fairly rare instances. Disputes between states or disputes between citizens of different states. In the cases of admiralty and maritime jurisdiction, in suits affecting ambassadors and other public ministers, and councils in which cases in which states are a party. Now, the number of justices is completely up to Congress. There could be one, there could be thousands. Nothing in the Constitution indicates how many there should be and what you should be using as a guide to determine how many there are. Now, as the number isn't mandated, it has changed over time. The initial number was set at 6. Briefly, it was set to 5, and it has been as high as 10. The number of Supreme Court justices never got down to 5 because it stayed at 6. Because every time someone's tried to reduce it, they've set basically not eliminating the existing justices, but allowing them to attrition out. And never have they been allowed to really attrition out, with the exception of when they went from 10 to 9. the role of the Supreme Court fits into what were known as the circuit courts. Now, you'll sometimes still hear the term circuit court used, but it's to a certain extent kind of archaic. The circuit courts were what became the appellate courts, essentially large districts of the United States under a particular court system. Now, initially, the Supreme Court's role in these circuit courts was to act as a circuit judge. And what that literally meant was that the Supreme Court, during part of the year, was expected to travel around his district, going from major city to major city, sometimes smaller ones, essentially dispensing justice. That's where the term circuit comes from, the riding in a circuit. Uh, Initially, Congress set the number of justices at 6 because there were 3 circuit courts, and they expected that probably one might be out at any time, so therefore it would allow at least 3 to be in place at any given time. The amount of justices increased over time from 6 to 10 up through about the Civil War. And then briefly, Congress set the number to 7 to prevent President Andrew Johnson from adding any justices. The court would eventually attrition to 8 while this was in place. And again, this was purely from Congress. No no constitutional change required. In 1869, the number was fixed at 9 and has remained so ever since. The Judiciary Act of 1891, commonly known as the Evarts Act, ended the circuit courts and changed them to appeals courts. At that time, circuit riding ended. The whole idea of having a circuit judge, one who actually traveled from place to place, comes from the English system, and we copied it over. It was considered very important to the founding fathers. The Supreme Court justices fought it tooth and nail, essentially from the beginning of the Republic until this 1891 law changed things. And it was hotly contested. A lot of people thought it was a critical and traditional part of our system. Now, FDR would end up attempting to add justices to the system, and this is what's known as court packing. Unlike what people are saying today, replacing existing justices who are termed or who retire or die, even if they all match your particular ideology, is not packing the court. That's a complete bastardization of the meaning of the language. Court packing literally meant adding court justices in order to get your way. So FDR was angry that the Supreme Court wasn't doing what he wanted. So he wanted the power to add Supreme Court justices for any justice who failed to retire at age 70, so that he could add up to 6 justices if there were 6 justices 70 or older who refused to retire. Now, what we'll see, and I'm sure this happened even before FDR, where essentially one aggrieved party believes the Supreme Court isn't allowing them to do what they want to do, so therefore they demand some kind of reform that allows the Supreme Court to do, allows or makes the Supreme Court form in a way that allows them to do what they want. We saw it with FDR. FDR was very adamant that he wanted this, and he was shot down. And there was very little. The only way it can be interpreted was, I'm not getting my way, so therefore we're going to change the court until I do get my way. And pretty much ever since, the courts, probably about for the last 60 years, we've been hearing conservatives cry and moan about Supreme Court is unfair and how it's set up, and they want some form of reform. And suddenly, when the Supreme Court composition, the ideology shifted with the Trump administration, all of a sudden, liberals are no longer happy with the court when they've been thrilled to death with it, basically since the 1960s until suddenly recently. Again, what we see is the call for reform seems to come from the side that's not getting their way, and that seems to have been our history. Now, one of the things that has been mentioned, and this is kind of talking about the idea that we need 13 Supreme Court justices rather than 9. And a lot of people on the left are saying, well, because the way it was set up was there's supposed to be a Supreme Court justice for every single appellate district. And appeals courts and circuit courts equaling the number of justices. There has been a bit of a tradition, but at the same time, not. It's at no point was it a hard, fast rule, and uh, there's not a whole lot of literature backing up the idea that we definitely wanted to have that. So essentially, your very first Supreme Court with the 1789 Constitution, there was 3 circuit courts and 6 justices, and as I mentioned, the idea was one might be out at all times and the other one might be in. In 1801, they doubled the amount of circuits to 6, and we still had 6 justices. Briefly, for a time, they tried to set it to 5, but that changed within the same year, and that was just some political maneuvering that was going on. However, it shows that they were willing to have 5 justices sitting on 6 circuit courts. 1807, we had 7 circuits, 7 judges. 1837, 9 circuits, 9 judges. And in 1855, we had 10 circuits and 9 judges. 1863, 10 circuits, 10 justices. And then in 1866, we had 9 circuits and then 9 justices that had traded down to 7. So they were willing to allow number of Supreme Court justices drop to 7, essentially less than the number of circuits. Uh, in 1929, there were 10 circuits and 9 judges. In 1980, there were 11 circuits and 9 judges. In 1982, there were 12 circuits and 9 justices. Now, the latest circuit court or appeals court that was added is kind of a special court. It's purely a federal court. It doesn't actually have a geographical region. It's essentially been assigned specific types of cases. So if you're trying to make the uh, Supreme Court justices have to equal the number of district argument, this doesn't fit because it's not a geographic region. It is just basically a set of circumstances. And then the 13th uh, district is very quirky at best. Essentially, there has been a DC court from the beginning of the Republic, more or less. And its status has changed over time, where at one point it was essentially called a circuit court, but it wasn't because it was too small to actually have someone ride it. And then of later, it would be called an appeals court and brought up to status similar to the other ones. So the DC court's been there the whole time, but it hasn't really been considered one of the uh, circuits or regions for most of the time period of the United States. So at the very least, the idea of the 12th and 13th justice doesn't even fit at all. And we can see, looking at uh, essentially the relationship between the number of justices and circuits over time has varied, where they're fully willing to allow the number of uh, justices to be less than the number of circuits numerous times through history. Uh, so essentially, it's a kind of, but it's a very weak argument. Essentially, it's bad justification. So if that's your primary justification for increasing the number of justices, I think it's a weak justification at best. Now, as I mentioned, at least, and I really didn't dig past earlier the FDR with various controversies, but obviously you saw the Andrew Johnson issue where Congress didn't want him appointing justices, so therefore they just basically blocked his ability to appoint them by reducing the number and allowing them to attrit out. And as soon as Johnson was out of office, they returned it back to the normal number of justices. So a lot of this is kind of sour grapes because you don't really hear conservatives pushing hard for reform now that they're getting their way. And you didn't hear the left complaining about the Supreme Court in any way whatsoever over the last 60 years until suddenly they stopped getting their way. So let's talk a little bit about the idea of term limits. As I mentioned before, Levine wants a term limit of 12 years and Biden wants a term limit of 18 years. I'm not really sure where they arrived at this. Here's an interesting data set. The average term for a Supreme Court justice, either based on dying in office or retiring, is 18 years. So Biden is setting the term limit at the average length of a Supreme Court's term. So not sure what he's hoping to affect. Maybe his sole purpose is getting Clarence Thomas out of there. Uh, However, the Constitution is very clear that Supreme Court justices get to serve as long as they have good behavior, which means indefinitely. There is no term limit. So, in order to have a term, there must be a constitutional amendment that cannot be enacted from Congress. Now, I'll just give you a little idea if people, because some people might be thinking, well, back in the olden days, people served a short time and then they just went on their way, and now people are sitting in there forever, and that's not what was in mind. Well, that's actually not true. Okay, so the 10 top longest serving Supreme Court justices, one is currently serving, and that's Thomas. Four of the top 10 longest serving justices were from the 1800s, one of which started his term in 1801. And then the remaining five top 10 justices started in the 1900s, most of them from the early 1900s, and only one of them from the 1970s. One of the original justices, I mean, one of the very first justices sat when they put six on the court. One of those six served for 20 years. So this is somebody who was on the bench the moment the Constitution was put into power and served 20 years from that point. And no one seemed to be bothered by that. So the idea that justices are serving too long a term or that there should be term limits is clearly not an originalism idea at all. Okay, to give that a little bit of context, the Articles of Confederation had term limits within it. The Constitution has absolutely none. In fact, it wasn't till the 1930s that the first term limit was added. Some states have begun adding term limits to their federal offices. But the question I keep asking for everybody who says, well, term limits, gosh darn, look at the guy serving there that I hate. Term limits would get rid of him. We have term limits in place in certain locales. My question is, does anyone have proof that term limits accomplish positive outcomes? What are the outcomes from term limits? My suspicion is that they're not positive. neutral at best, and most likely negative, because I suspect the more you term limit people, the more you're going to shift power into the hands of the bureaucracy. So you probably already got an idea where I'm going on that one. um, when we look at what they were attempting to achieve, obviously we understand that they were setting up a republic. This was not, especially the justice part of the system, was not meant to be democratically influenced. The goal was, bar none, stability. And we can see that the Supreme Court has been extraordinarily stable. Essentially, the Supreme Court kept the United States together through the entire antebellum South period. Um, they, uh, perfect example, Dred Scott decision. There were numerous dissenters who said, "Hey, we're voting, keeping slavery and fugitive slave laws intact, but we're against them, and we really think Congress should do something about this, in terms of constitutional amendment." Now, if you look at the court between if you compare like the 1920s court to the 1960s court, there's quite a difference between them. Uh, However, the change was very slow, plodding along at a certain point to where the court kind of caught up with the mindset of the people, and they gave them uh, certain considerations that met the society of the time. If you compare the court of the 1970s versus the court of the 2020s, well, you can see once again there was a long period of time before things changed. Obviously the biggest sticking point is something like abortion. Okay, well, the abortion item, it's not like it's been flip flopping back and forth over time. It's taken multiple generations for this reconsideration to occur. And to a certain extent, it is mirroring what the population wants as opposed to what the establishment wants. So, in terms of term limits, I'm kind of fond of stability uh, in certain areas. Uh, I don't think we have a benefit of having the Supreme Court changing at 12-year intervals like Levine. Now, I imagine he has some sort of staggered system, but still, you're talking about a fairly rapid change compared to what we have now. If the average term is 18 years and he's going to mandate that all terms are 12, this is going to radically alter the stability of the court, which doesn't seem like a good idea to me. Um, Biden's idea of 18 years is going to speed up the turnover of the court as well, just not as rapidly as Levine's idea. I don't see messing with the stability as being a good idea. And once again, with a total lack of proof that term limits have positive outcomes, I have a hard pass on this idea of term limits. One of Biden's ideas is a code of conduct written by Congress, enforced by Congress. Now, the problem is it's very nebulous. What stops the code of conduct from being constantly fiddled with? What I see exactly happening. I would assume that constitutionally, a code of conduct is probably completely unenforceable. If a justice does something that violates your code, what do? You can't fine them, you can't remove them. Who enforces the code? I see the code of conduct, again, being something that's going to be constantly messed with, constantly changed. Every time somebody sees a justice that they don't like, they're going to look for a behavior that they're going to say, oh, well, we're going to add this to the code of conduct so that now the behavior they're doing matches a violation of the code of conduct so we can go after them. So I see this leading to endless investigations. There'll probably be endless censure hearings from Congress on this. Okay, this sounds like a method solely to put political pressure on the court. And I don't see this as valid. The Supreme Court is supposed to be insulated from the day-to-day political activity of the rest of the government. The remedy of impeachment is already there in the Constitution. It's just that Congress doesn't choose to do it because very little of what the Supreme Court members do rise to that level. Now, an interesting idea Levine has is to allow Congress or the states to overturn a Supreme Court decision within 24 months with a 3/5 votes of the members of the houses or states. I'm not sure. So this is something I'd say definitely ask in the comments below. What do you suppose? Let's say this power had been in place. What do you think in terms of Supreme Court activities has been so ridiculously unpopular that it would generate the 3/5 vote required to overturn its decision within 24 months? I can't actually think of anything that's been so egregious. I mean, yeah, there's been controversial things, but has it been 3/5 controversial? So I'm curious if you have any thoughts on that. And what do you have on thought? This is one I'm kind of, I'm not for or against it. I do find it intriguing. What do you think of this idea? And can you think of anything that you believe actually would have been overturned? One thing I think would be a good addition to the court would be kind of an internal check. Because these guys and ladies get to see each other all day long for many, many years. They know what shape they're in. I'm thinking it might be a good idea, and this would have to come by constitutional amendment, where essentially, if the totality of all the existing justices said that, hey, one of us is having problems and they need to go. So, like in this case, since we have 9 justices, if all 8 of the other justices said that one of them was a problem, I could see that as a very good check against the system, because what it would do is if someone was getting very senile or someone was being very corrupt and it was so obvious to the rest of them to be egregious that 8 of them said, hey, you have to go. And by doing it completely in-house, I think it could happen transparently, where essentially the 8 justices go to the one and say, hey, look, what you're doing, or basically your current situation, you can't be here anymore. And we're going to all vote to basically impeach you and boot you out of here. Do you want to resign instead? And so what it would do is it would allow us to get rid of people who are an incredible problem without necessarily turning it into a circus that the rest of the world needed to see. But that's just my thought. Any thoughts on that in the comments below? And if you have any other ideas of reforms you think would be useful, leave about them below. I'd be interested in hearing them. Please smash the like button. If the YouTube algorithm brought you here and you're not a regular subscriber, look at my other titles, consider subscribing. And of course, if you know someone who might find this useful, please share it with them. Thank you for spending time with me this evening. Hope to see you again in a future video.